Hi, welcome to This Week in Property. I'm Jayashree Kurup, I'm editor, Magic Bricks. I have Sobia Khan with me from the Economic Times. There's Bhagyalakshmi from Fight for RERA and Mr. J.C. Sharma from Sobha Developers. Do model builder-buyer agreements help? And is Karnataka suffering because the builder-buyer agreement is not a signed document yet? This is the issue that we're talking about. We have been telling you that we'll be addressing it, and a large number of you have already posted some of your queries on the site. But let's first get our panel to talk about why this builder-buyer agreement is so important. Mr. Sharma, some time ago when we saw that builder-buyer agreements were very skewed in favor of developers, consumers have raised this issue. RERA has addressed this in many ways. What is your take here?
To begin with, let us all agree that this Real Estate Regulation and Development Act, it is for the benefit of the real estate sector. And it cannot happen until and unless the consumers, the customers, you don't keep them as the central focal point and ensure that they do not suffer. And if you look at even post the RERA Act also, the way the consumers continue to suffer, it is a matter of concern and we need to address it. Through RERA, what was envisaged was that let there be a central act and let the Indian consumers have a comfort and clarity that all the developers fraternity throughout India, they should consider RERA as the central focal act and should start working keeping its provisions, its requirements in mind. But if you look at, even with that kind of a good intent, having many states implementing it, the way it got implemented is an issue we need to also look at. While everybody talks about how Maharashtra has ensured that the RERA gets implemented in letter and spirit, and from the consumers to the developers to the bankers to all other stakeholders, they appreciate. We find that the degree of implementing the RERA Act in letter or spirit is yet to be improved upon. And there, this issue, a model buyer agreement, definitely also needs to be addressed. I personally feel that yes, if you are giving an authority to a party, right, it may be a developer, it may be a customer, it may be a banker, normally they and their lawyers will be drafting that agreement, primarily ensuring that the interest of the person who has given the mandate is protected, and at the same time they need to follow basically the other acts, other provisions, and they ensure that yes, the customers also should not be taken for a ride. However, because of the way in India you have got a framework where certain things you can put it across the way you want, it was desirable that every state government comes out with its own buyer agreement. It needs to be put for the public debate and deliberations. And once it is approved, it needs to be implemented across all the developers, all the bankers, all the consumers. And the more it gets delayed, more some kind of a discomfort, definitely the system starts getting. So we are for it, and we believe that post this new government getting formed, this is one area which this government will look at, and something of a standard model agreement is put across.
Sobia, let's talk about why a builder-buyer agreement is so important. You and I have been reporting about the RERA and the issues that real estate consumers have been fixing. Right. So why is this builder-buyer agreement so important?
I think, Jayashree, it's important because, considering there are so many delayed projects, people are stuck with their money. There's no clarity on projects that will come on ground right now. We have cases around different cities. So I really think that once this builder-buyer agreement come in, people have more say. As a buyer, I can have more say in the project. And also the fact that right now there are many builder-buyer agreement where it's more skewed towards the builder. that can be taken care of once this builder-buyer agreement comes in. But the fact here is that it's been pending for 2 years now, and state government needs to do something about it and speed up the process.
Actually, Bhagyalakshmi, let's talk about the RERA, the unsigned document that is uploaded on
Yes.
RERA right now.
No, I would like to come in here at this point. When Mr. Sharma was saying that the regulator is very much acceptable to the builders, which is not the case actually. They never wanted a regulator in place at all. It was the buyers' forums which fought for a regulator called the Real Estate Regulatory Act to be passed by the central government. It was Mr. Rajiv Chandrasekhar who worked a lot on this particular act to be passed.
I agree with you, but right now the act is there.
Yeah.
And
Coming
16
to
states,
that,
one minute.
it is basically for the buyers that this particular RERA
Absolutely.
has been constituted.
Absolutely.
This is the point which I want to say. And the entire builder community is against it. They, at all points of time, they don't want the RERA to function.
Can we talk about the issue that we're addressing?
Yeah.
Why
Yeah.
do we have a builder-buyer
Yes,
agreement,
coming
and what
to
are the provisions that are useful to the
Early,
consumer?
pre-RERA, that's why I'm coming to that point. Pre-RERA, the agreements which are signed were all unilateral agreements and one-sided agreements which were against the Competition Commission of India, the rules of the company. The dominating position of the builders were always exploited against the buyer or the customer. The customer walks into the office of the builder, and the builder shows a format saying this is the generalized format followed by all builders here. We cannot make any changes to it. Though we try to do a due diligence on the agreement of sale, it is never accepted by the builder. And they always say once there is a sale deed superseding
So
it.
RERA has
Okay.
come in because these issues were there.
Exactly.
Now let's talk
It
about
is
in the
a
RERA
one-sided,
period. In the
agreement
RERA
which
period.
has led to a standard format which we all require now to.
Sure.
Oh,
Now in
now
Karnataka,
RERA
there is
being a
one minute.
central act.
Please come
Yeah.
out. In the Karnataka
Yeah,
RERA,
I'll come to Karnataka.
one minute. In the Karnataka RERA, the provisions when there is a consumer, what are the provisions that a consumer must be aware of? Let's first pick up those provisions.
Now, can I just tell you about the AFS and where it's pending at Karnataka? Because RERA Act is a central government act. The rules should have been notified by the state,
Right.
which was notified a year later after the passing of the act.
Yeah.
That is in 2017. Right. Once the rules were passed, the agreement for sale, the standard format, should have also been passed by the cabinet and sent to the RERA office or uploaded into the RERA website, which did not happen. In fact, they say they forgot to do it. I don't know how they can use this word, forgot to do it. And after a few months, once we people asked them where is the standard format, they uploaded, they brought out a format, and they said they called for objections and suggestions from the public.
Has that been incorporated?
Yes, we objected. We from FPC has objected most few things over there, and we have given our suggestions, and that has, as it is, been linked to the RERA.
Is it only your suggestions, or were there others also?
There were other NGOs.
So there are a
Yes.
lot of people
There are
to help you
for the
understand.
concerns who have concerns of
To help our consumers understand, in RERA, there is a standard builder-buyer document that can be uploaded. 16 states today have done it. Karnataka has uploaded a document, but it has not had the cabinet approval.
Yes.
There's been a lot of political
Yes. After
upheaval
the
and so on.
suggestions were accepted.
Let's
and
let
it
our
was
consumers
cabinet.
understand.
Yes.
If today you can, it was open for consumer suggestions, and many of the suggestions by agencies like Bhagyalakshmi's as well as various other organizations have been incorporated, and the incorporated document is available online.
It's
Now-
been linked, that's all, to the RERA website.
So you can
but
go
it's not
online.
an approved document.
I understand. So you can go online and check whether the suggestions have been incorporated. Today, what we're discussing is, with that, without that signature, without that approval and the signature from the cabinet, it is not a valid legal
Yes.
document yet.
Yes.
However, the fact is that you can see what the draft document is. It is not yet a valid legal document.
Yes.
Now, why is a builder-buyer agreement so important? If you're going to buy a property and whatever you sign on that builder-buyer agreement, earlier there was no agency you could go to other than the courts, and it used to be a long process. Today, with RERA, many states, many RERA authorities are saying that if what is in the builder-buyer agreement can be enforced. If say somebody from a developer's office promised you that I will give you 3 more extras, but if it's not in your builder-buyer agreement, it cannot be enforced, right?
Yes.
Sobia, do you see this kind of problem where consumers say that somebody told me that this was to be given to me, but it's not reflecting in that builder-buyer agreement?
So, a lot of cases have come up where people have been promised that I will give you X number of amenities, or I'll give you, say, extra discounts or something, but that doesn't reflect unless and until you have it documented. It still applies in the current document, because when you go to legal court, they will look at your documentation rather than that verbal agreement that you had with the builder. So in that sense, if builder-buyer agreement is in place and they can take care of these things where a builder has agreed to certain amenities which was promised and which is not there, then yes, in that sense, it will definitely help the consumers, and you will have, forefront in that sense.
So we've got a couple of queries that have come in. That Deepak Singh, who says, what should a consumer look for in builder-buyer agreements as per RERA? Would you like to?
Yeah. The builder-buyer agreement basically, as the term suggests, it's an agreement between the promoter, that is the term used in RERA, and the allottee, who is going to be the buyer. Okay, this is an agreement of terms and conditions, including the rights and duties of both the promoter and the buyer. That's what is defined as the right. So he can look into most of the rights which are enlisted in the RERA book to be present there, and he will also have
name some of the key.
I can. Let us say section 19. I think suggests the rights and duties of the buyer. The rights are right to knowledge or right to information regarding the specifications of the project. Right. Okay. Not only specifications, it's also it refers to the orders, the plan sanctions available, all statutory orders, compliances with various bodies, like if it's a revenue land, the conversion order and things like that. So he gets the right of information of all these documents by means of a builder document, that is the AFS.
Will all this go into the builder-buyer agreement?
Yes, it has to go. It has to go with the standard,
so, which means the land, the land titling
regarding the project.
Yeah.
Okay, and all orders, plan sanctions, okay, in place, and anything else regarding taxes, etc. The promoters' details.
That goes on the website. RERA website.
No, they have to come onto the agreement also. Okay, okay, they have to come.
Fine.
What he is uploading is his rights and duties. Now, when you look into the promoter's rights and duties,
let's pick up 5 things that are must-haves on a builder-buyer agreement.
On an agreement, okay. Specifications of the project.
Specifications.
Okay, number 1. Then it's going to be all statutory orders, whether they are in place. Because, for example, if it's a DC order, the number of the DC order has to be mentioned over there. The plan sanctioning authority, the plan sanctioning number of the sanction number. Similarly, other statutory things like BESCOM, water supply, sewage board clearances, then other clearances from the fire department. Everything should be mentioned.
Okay. Mr. Sharma, let me come to you.
So buyer has a right to get all this.
Now, you have been involved in the RERA discussions right from the beginning. Help me understand, what are the 5 things that you think are must-haves in the builder-buyer agreement?
See, I think to begin with, such initiatives we should applaud. Basic idea, again, as I repeat, is that the customers, the consumers, they should not be suffered by it, irrespective of whether X or Y is happening or not happening. And we are not with our customers in an adversarial position to begin with. Right. Coming back to the issues, somewhere when we are not at an adversarial position, as I said, a standardization of an agreement, even we welcome. Right. We would like to know from the people who feel that as if the developers have come into the way with clear-cut examples. To begin with, as far as I am concerned, I not only represent my company, I represent the sector also. We have an apex body, CREDI, and we are here to ensure that our members behave very responsibly. And coming back to the issues pertaining to the buyer's agreement, it is given that the land title has to be there. It is given that all approvals need to be in place. It is given that the specifications must be communicated to the customers upfront. It is given that the payment terms needs to be communicated clearly.
According to the level of construction, right?
There are majority of the cases, what you said, right? There are very few developers who also have a fixed time payment and it is not linked with the construction progress.
But that RERA says that it should be construction linked now, right?
But since still the buyer agreement is not yet standard, some of them may be doing or may not be doing, not to my knowledge. Correct.
No, that stages actually comes in when you upload the quarterly report.
Let me come back.
So the quarterly report of the project is also.
So one is that construction linked to the payment part, and the next one is the rights and responsibilities of both the developers as well as that of the customers, sort of thing. These are the 5 things we need to focus on.
Sure.
Now, also just to make things comfortable, because the agreement is not there in Bangalore or in Karnataka, but if you look at the basic comfort what a Karnataka consumer has got vis-a-vis on an all-India basis, the kind of delays and the suffering which the sector has been going through, it is happening despite this buyer agreement is not there. And even if on those 16 states, if that model agreement is there, it per se does not assure or guarantee that things will not happen. What I am trying to communicate again is that we need not have to mix up the issues. The buyer agreement has to be there, has to be standardized. We are for it. Right? My company is for it. So the issue is bigger than that. The issue is that the RERA Act is meant both for regulation and for the development. And irrespective of whether RERA Act is how far effective or not, the courts in India, they have accorded a financial creditor status to our customers, which was not there or even otherwise also. So the law of natural justice will always be preceding, and the consumers to that extent are well protected. But the context has to be taken into mind that we are here to ensure that the industry develops meaningfully. And the people who are at fault or who have been deviating from their commitments, sort of a thing, how the RERA and the people who are fighting for the consumers, they are able to differentiate and take the right kind of steps, then to get agitated or feel as if the developers fraternity here is meant to only ensure that the customers are put into problem. They themselves are also got into problem, those who have been delayed, right? Their properties are being taken over, somebody else is doing so many things on their properties. So net, our view should be that the RERA, which according to my understanding, we also want it, right, needs to be implemented in letter and spirit.
Absolutely.
And ensure that whatever provisions the Act has, let it be implemented. That is why I support Maharashtra, because there it is happening in a proper manner. Let that become a model, that it become a standardized method of managing the sector to ensure that this industry grows and the housing for all and the affordability improves.
Sure. Now let's, we have a very large number of queries that are coming in. There's Nidhi Mathur who says, what are the rights and duties of buyers and builders under model builder-buyer agreement under RERA? You want to talk about that? What are the rights and duties of consumers as well as builders?
The rights and duties, we derive it from the RERA Act, and Section 19 actually explains the rights and duties of a buyer, where the rights, under the rights section, they are having the right to inquiry or right to disclosure from the builder all details regarding the specifications of the project, the orders, even to the extent of charges involved in the project. We are trying to introduce 2 more schedules there to the existing plan, what do you call it, AFS, wherein you have charges which the builder has created on the project should also be revealed to the buyer, and the litigations which are there already existing on the land. Because the buyer who is buying should not be left with some minor interest and things like that, which is coming up at a later date. And those are also one of the reason for the delay in project and for shutdown of the project, the stay orders that they bring. Because when there is a joint agreement and there is a joint venture deal that the builder does, the landowner normally keeps 2 or 3 members out of the purview. That is what we are hearing. Yeah, you got. Now, in such a case, when there is a minor involved there, a minor interest crops up after few years. That is what I have heard. Okay, such things should not affect the buyer who is going into an agreement with the builder. And his duties will be, as far as payments are concerned, he will be told about the refund process, then the interest, the delay compensations, all that comes under the duties also. Payment is the main thing. And he is also informed that he has to become a member of the association once the builder hands over the project to the association or the RWA. So these are the duties. The rights of the builders are under section 11 of the RERA Act. And there, under that, he normally, when he starts the project, he logins to the RERA website, he collects a password, starts a website, okay, for that particular project, and starts loading in all the details column-wise. What are the details? The specifications of the project, how many units are going to be there, how many are booked from time to time, okay, and what is the stages at which the project is undergoing construction. All those things have to be entered. Under the duty part of it, he is duty bound to inform the buyer about the litigations involved, all the orders obtained by him, all sanctions obtained by him, all statutory clearances which are there in the project. He should also inform the time limit or the time-bound nature of the project, how fast he is going to construct this particular project and finish it, and honor that particular time which he has given. Otherwise, he goes into a penalty or a defaulting way. And after the time bound, he is also going to inform when the association will be created for the public.
That is after the handover of the
That is also one of his duties. So the completion is also going to be further, the OC and other things will be produced by him. The important documents required by the buyer will also be.
So remember, you have your rights and duties, and the builder has his rights and duties. And as a consumer, you have to ensure that your payments are on time. You have to go with the builder by agreement, and the developer's role is to deliver on time and deliver to the specifications promised in the timelines with, I think, a 70% escrow accounting of the money receivables that are from the consumers, so that the project can be funded. In many cases where the money was taken out of the system, to subvent that, you're ensuring that the money goes into an escrow account. Mr. Sharma, you wanted to.
See, again, what I would like to reiterate, whatever we have heard so far, it is in any case there in our existing agreements.
Okay.
Right, the specifications are there, approvals are there, the rights and obligations are there. What we are talking about is it need not be one-sided. So the standardization happens where if it is coming through a third party with the government, state government, it has got that more comfort, and whatever bias the developer fraternity probably was putting through, it gets eliminated. But otherwise, the buyer in any case today is reasonably protected, and even if it is putting anything which is one-sided, the Indian courts and the systems are capable enough of taking care. Madam had put forward certain good points like the legal issues. The legal issues for which the title insurance also is talked about, and it is the responsibility of again the state government to ensure that the land which is in the possession of the landlord or with the developer, with the khata given by the state government in the name of the landlord or the developer, and the approval being given after doing the due diligence about that particular land parcel, the right of the claimant needs to be protected. We are not again against that, but it should not hurt the project and the consumers. And for that, if the idea is to ensure that the developers have got some kind of a magic wand to protect the consumer, it is just not possible, because this is the right which anybody today has got to file a PIL or to file a writ. So we need to understand that the environment in which today we work and operate has to be appreciated, and the idea should continuously be there that somehow keeping the same consumer into the mind, certain things which by practice, by the multiple examples we find, there has to be a mechanism to get addressed. And if the RERA can play an important role as a platform to address such issues in a faster manner, it will be good for the sector.
Sure. There's Mohit Kumar of Bengaluru who says, what can buyers do in case builder-buyer agreements, which were one-sided, has already been signed? Can buyers demand changes in it?
I don't think you can do that because you have already signed the document and you have agreed to what is written in it.
The document that you signed before RERA came into being was ruled by the Contracts Act.
Yeah.
The documents that that are in force post the RERA is governed by the RERA Act. However, what we have seen is there have been many instances across the country where the builder said that I'll give you 5 rupees per square foot penalty if I'm delaying it, but you have to pay me 18% when if you delay. Now, these the courts have addressed. Like Mr. Sharma said, the courts have addressed this by saying that there is a MCLR plus 10 is what the
Very well said.
what the courts are granting. All RERA courts, whichever state you are in, the rates have been fixed, and those are the rates that are permissible till the date that the builder promised. Suppose the builder had promised that he would give you the project, hand over the possession of the project in March 2019, for instance. Till March 2019, the builder is governed by the Contracts Act, the builder-buyer agreement that you signed.
Yes.
After March, any project that comes, if the project is delayed, the compensation is as per the RERA rules, which is MCLR plus 10, right? And in which case you get that you are awarded compensation at 5 rupees per square foot till March 2019, and after that you get it beyond according to the RERA rules. Now these are some of the practices that RERA is a new act. It is being interpreted by various laws across the country, and as the interpretations happen, there is more and more clarity on how this evolves. Like Mr. Sharma said, the new acts are all going to be in the according to RERA. The older acts will be governed by the RERA rules if they exceed the time limit that they had promised.
Can I just add?
Yes, please.
Yes. Now, you were talking about the Contract Act. Okay, the Contract Act also says there should be a satisfaction from both the sides. At any point of time, if there is going to be a dissatisfaction or something found out that he is being manipulated by the builder, he can always terminate the agreement.
Sure.
He can go in.
According to the Contracts Act, that's a valid point. The Contracts Act does allow you to terminate an agreement.
Yes.
However, if a buyer is looking to stay with the builder through the project and get the possession of the unit, till the time the builder has promised to deliver it to you, you're bound by the Contracts Act. After that, it is the RERA Act. There's Niti Rao of Bengaluru who says, can builder mortgage the flat even after the registry is done by the buyer? Can a buyer challenge this clause in the builder-buyer agreement where this condition is mentioned? Mr. Sharma?
See, today when we look at a project, say for example, with 100 units, correct, out of which X number is booked, blocked, or being sold, and the Y remains available with the developer. To that extent, whatever the developer has got the stake, he can always sell it, or he can, if he can sell it, he can mortgage it also. Right. But what we are seeing, and which is a fortunate positive development, today the bankers have become much more smarter than what we have seen in the good past, olden days. And they are not giving the money indiscriminately. Thanks to RERA, thanks to the better understanding about this sector.
And
thanks
tightening
to
of
the-
laws by RBI and NHB as well.
and thanks to the ability to track the track record of the developers also.
Yeah.
So I keep reiterating, whatever we are talking today, whatever we are going to do today or support today, it has to become a positive, constructive building block to ensure that tomorrow the sector becomes a viable sector. And for that, the customers and consumers' interest has to be paramount. And again, I keep communicating, for that purpose, we need to ensure that the spirit of the act is never contravened, and the developer has to be looked at as one of the key important aspect of the whole spectrum, not the only responsible guy for all the delays or for all the problems.
So Niti
Regarding
Rao,
mortgage, can I?
yeah, please.
Now, he was saying that when there is X and Y apartments in a particular complex, X is sold out and Y is remaining with him. He has the right to mortgage or sell it or rent it. Okay, it is left to him. But in a document that is made for the purpose of mortgage, he is expected to mention that these are the Y apartments which are available with me, and the Y's UDS is mentioned there, and this has to be
This is being
informed
done,
to the
madam.
buyers.
This is-
No, sir.
No, you do not.
No,
That is my
it is
point.
not done. I don't want
no.
to
Can a
take
buyer,
the name.
one
I
minute.
don't want to take the name of certain builder who
Bhagyalakshmi,
is
can
doing
a
it.
buyer, the question
Yes.
is, can a buyer challenge the clause in the builder-buyer agreement where this condition is mentioned that even
You
after
mean to
registry?
say at the registration of the builder-buyer agreement, there was a loan, is it?
No.
Is
Can a
that is-
builder mortgage the flat even after registry is
Registry
done by of the
AFS.
unit is the
Of AFS.
yeah, of the unit is done by the buyer.
See, the builder normally has charges on the land, the flats, everything till the conveyance of the flat, right? Okay. So when this person is having an agreement of sale with him, the builder can go on till the conveyance deed is made. That is the sale deed is made. But just before the sale deed, he is supposed to take an NOC from the bank or financial institution, give it to the person, and then go ahead with it.
So once it's registered in your name and the conveyance is made, then that property cannot be mortgaged.
Cannot be mortgaged. Yeah. And one more thing I would like to say, Mr. Sharma can know about what is happening in the market because this is of lot of concern to all of us. There are certain builders going by the ROC for mortgaging the property. Okay, hypothecation deeds are made through registrar of companies, wherein it's an unencumbered mortgage. Unencumbered mortgage is never seen in the sub-registrar office. Even if I want to check whether my flat is under mortgage, I go and get an EC, what is called as EC. I will not know whether this builder has mortgaged it or not, because his mortgage is from the back door. It goes into the registrar of companies, and he gets a bank to finance him for the sold and the unsold. I have seen clauses which write saying that sold and unsold units
As
are
project
under
finance.
hypothecation.
As a project
No,
finance.
it is for his as a finance. That's all. It's a
It will
loan.
be- it will be for-
It's a
For
loan
the project.
For the project.
for
Ma'am,
the
when you-
project. Okay, the project is completed, sir. In that case, what do you say about it?
See,
A completed project.
again and again, I think the basic purpose of such dialogue is to educate the consumers of their rights,
We are
responsibilities.
doing it. We are doing it.
You must do it, and
We
we
are
welcome that.
Yeah.
And it's a welcome step. Please continue to do it.
So
No, no.
Niti Rao, what she's asked is, can the builder mortgage the flat even after registry is done by the buyer?
No, not on his or her apartment.
On
No.
your apartment cannot be mortgaged, when the builder takes a mortgage for the project, that entire project in which your unit is one of the units,
she gets affected if he defaults.
Yeah.
If he defaults.
I think
Now, we have to understand that.
Understanding. I think
It is.
No.
It depends
let's
upon
move
the
on to the
document.
next. We have about 8,
No,
9
the document
queries
which
more.
has been described, it depends on that.
Okay, now we've got Rakesh Sharma who says, can builder buyer agreements be allowed to be one-sided under RERA? In post RERA builder buyer agreements cannot be one-sided.
Yes.
That is what the law states.
Yes.
And there are
to begin with, it was never one-sided. As we say, those 5 important points, what you talked about, was always there. What was somewhere lacking is you have also highlighted on the penalty issue.
Yeah.
And for that, there were certain logics. The issue is if you delay, you must suffer. This is the consequences part. Nobody is getting into that domain where you cannot make the buyer suffer, whether RERA or no RERA. So
actually there were imbalances. A builder paid less penalty, the buyer paid more penalty. The builder was free to take money out of one project into the next project.
Yes.
That is not possible in the RERA
Absolutely
era. 70% of the finance has to be in the escrow accounts, which is, and construction linked payments is the norm that RERA recommends, not time based, so that if the project is delayed and one stage of construction is not met, then the next installment is only taken when that
Also, with the RERA coming in, I think consumer also have more power now. And you have various other law that has been come, whether it be in the form of IBC or you approaching NCLT. So consumer has more say now. But the only thing which is lacking here is the model sales agreement. Once that comes in, you will have your say in the whole agreement as well.
And why is Karnataka, why are we singling out Karnataka? Because this is one place where the builder buyer agreement, assigned builder buyer and approved builder buyer agreement is not on the
2017.
Yeah, it's online since 2017. It needs a sign off by the cabinet, which is why we're talking especially about Karnataka. We're sitting in Bangalore today. We're talking from Bangalore because we felt that this is an issue that a lot of consumers were raising. Yes, there have been imbalances, and RERA has tried to balance many of the imbalances. And let's go on to some which are the issues that consumers are raising. There's Mukesh Reddy who says, where can one file a complaint in case the builder buyer agreement violates ownership rights? All your complaints have to go to RERA, right?
Yes.
Today you can, as a consumer, you can go to the RERA website. You can make your as a buyer, you can make your complaint there, and RERA gives you a date when you and the builder are called in to.
Surprisingly, if you look at nationally,
Yeah.
the developers have been trying to convince both the RERA as well as the consumers to let all the complaints be handled by one single competent authority who has got all the records, all the documents, or the history sheet about a particular project. But what you are seeing nowadays is, despite RERA being there, consumers are going to the consumer court also, they are going to the NCLT also, and they are trying to see to it that wherever they get have their issues addressed faster, they are going. What we still feel, RERA is a beautiful act. Right? It has come through huge consultative process. It has taken its own time, and it is taking its roots. This should be the act which needs to be nurtured, which needs to be supported, and ensure that via this act, the regulatory part and the development part, these are the two basic preambles this act talks about. It takes much deeper and better roots, and we hope that we are in that direction. Whatever delays which are taking place, thanks to this kind of a proactivity, hopefully the authorities will take note of such things and ensure that the model agreement is in place, and whatever one-sided part of the agreement which probably was there here and there, it gets addressed. At the same time, the delay is a delay, irrespective of whatever may be the act, it needs to be avoided. And the challenges which the developers fraternity they face while completing the projects, including regulatory, including the legal part, needs to be also addressed, needs to be understood to ensure the healthy development of the sector.
This Anita Sharma who says, how do I check the legality of a builder by agreement? Once a builder by agreement, once it is a registered document, it is a
I can say very simply, look at like this. Normally, a buyer should engage a lawyer, right? And if they are going for a bank loan, the banks also engages its own lawyer which approves the project.
Yes.
And the developer always will have a lawyer. So it is a matter in which the three lawyers, they apply their mind to ensure that the right kind of clauses are inserted and the interest of all the stakeholders is ensured.
So she's also asking, does the builder cease to become an owner of the project once it is handed over to the RWA?
See, once the association that in here takes over the project, the developers is duty bound to hand over all the drawings, all the documents, all the sanctioned whatever things, fire, NOC, or the BWSSB, or BESCOM, or environment related things, and they become the owner of that particular
60% of sale normally an RWA is formed, and they do the handover of the entire.
After which the
After
RWA is
which-
managing.
Yes.
But remember that RERA does have a 5-year zero defect liability.
Yeah.
The developer
structural
on
part.
structural on structure and workmanship. So these are the two things where you can go back to the developer and say that if
Very
there are
well.
any
Yes.
deficiencies there, the developer is still responsible, but otherwise the maintenance is with the RWA. There is we have recently in the newspaper, we heard a bank has told the home buyer to vacate the house in one project, and about 200 home buyers. That has been reversed. The authority has already, the authority has already said that was meant for the developer and not the home buyers. And in fact, the Supreme Court has said that they have to be given their OCs.
Yeah.
This was in Greater Noida. There is Vijay Patel who says, what are the key challenges one faces in states where they don't have the model builder by agreements as per RERA? That is where there is a model act. There is a model builder by agreement in the central act. The states have to get their own acts and approved builder by agreements have to be uploaded. As in the case of Karnataka, it is a agreement that is not approved yet, and it is uploaded so that people can give their suggestions, both developers as well as consumers, and people like Bhagyalakshmi have been working with the consumers to make sure that these objections are.
But in absence of that, they will have to continue with the agreement that the builder signed with them.
Right. However, if the agreement is one-sided, today what we see is that there is a definite
Their
bias.
rights are not construed because of that. No, they may sign an approval letter or whatever is the document with the builder, the people who are buying now,
Yeah.
before the AFS.
Yeah.
But their rights are always upheld because of.
There are a lot of issues that you have raised. There are a lot of issues that you would want to raise. Keep posting these queries, and we'll bring more experts like Mr. Sharma and Bhagyalakshmi to address your queries. We had a poll running on our site. Is your builder by agreement as per RERA? Just 33% say yes, 67% say no. Remember that in the post-RERA era, there has been fewer launches, newer projects have been fewer. So the agreements that you signed in the pre-RERA era is still valid. But like I said, till the date when the builder was supposed to hand over the flat to you, the old agreement provisions of penalty are valid, after which the new RERA penalty provisions are there. Thank you so much for joining our show. I'm Jayashree Kurup, and this is Sobia Khan, Mr. Jayashree Sharma from Sobha, and Bhagyalakshmi. Thank you so much for joining us.
Thank you. Thank you, ma'am.